of the majority, Congress shall make no law abridging all of these things. That's because those were the things that were of concern at the time. It's easy to be in favor of liberty and equality and free speech when it's popular. I think that I want to give my colleague, Mr. Sean, an opportunity to explain to all of us the legal analysis on jurisdiction. I'll be quite frank with you. We changed what we were going to do on account that we thought that the House manager's presentation was well done. And I wanted you to know that we have responses to those things. I thought that what the first part of the case was, which was the equivalent of a motion to dismiss, was going to be about jurisdiction alone. And one of the fellows who spoke for the House managers, who was a former criminal defense attorney, seemed to suggest that there's something nefarious that we were discussing jurisdiction and trying to get the case dismissed. But this is where it happens in the case, because jurisdiction is the first thing that has to be found. We have counter arguments to everything that they raised, and you will hear them later on in the case from Mr. Van der Veen and from myself. But on the issue of jurisdiction, the scholarly issue of jurisdiction, I'll leave you with this before I invite David to come up and give you the erudite explanation. Some of this was shown on the screen, but Article 1, Section 3 says, judgments in cases of impeachment shall not extend further than to removal from office and, and disqualification to hold any office of honor,
clear
trust,
it's within
profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So this idea of a January amnesty is nonsense. If my colleagues on this side of the chamber actually think that President Trump committed a criminal offense, and let's understand, a high crime is a felony and a misdemeanor is a misdemeanor. The words haven't changed that much over the time. After he's out of office, you go and arrest him. So there is no opportunity where the President of the United States can run rampant in January, at the end of his term, and just go away scot-free. The Department of Justice does know what to do with such people. And so far, I haven't seen any activity in that direction. And not only that, the people who stormed this building and breached it were not accused of conspiring with the president. But the section I read, judgment, in other words, the bad thing that can happen.
Yeah, I don't think you want to do the criminal thing with a politician like that. Like the very thing that he's talking about is you don't want it to become a retribution-based system where the new person is in charge.
Which of those words are unclear?
You're gonna
shall not
take it out on them.
Than removal.
You don't like. I think you would much rather have all the politicians in the room decide like this person should not be a politician again, instead of like having a threat of being arrested after every transition of power. I sort of don't think people would be unreasonable enough to just start impeaching people left and right because they know it'll happen to them too. They're politicians too. But with this criminal charge, like that is definitely a step too far, unless there's like something very major found, right? Like the issue here is about decorum and not encouraging or letting, come about the violence that happened it's not really necessary that he have committed a crime. I mean, the crime that Bill Clinton was accused of was lying under oath about having sex with an intern.
Quick adjustment. I stand
that wasn't
before
really
you
about a criminal charge in the first place.
As the hallowed ground of democracy.
And, I mean, to be fair,
in this
he
room,
was a
American
person
lives have
in
been
power,
changed so dramatically
and
in just my lifetime through so
Monica
many of your
Lewinsky
legislative
was an intern.
initiatives. From the Civil
There
Rights
is
Act,
something
when I was
about
a
the
child,
decorum there
through most recently the First
that's
Step
worth
Act.
investigating.
Laws that have provided major opportunities
And so
for
too
Americans to
is it
move
worth
forward
investigating
and upward
whether
and more fully enjoy
Donald
all
Trump
of the attributes of what has been the greatest
played
nation on
his
earth.
presidency
I've seen
like
the
a
changes
reality
these laws
TV
have made
star,
for my clients every day for the past 36
which might
years.
be like refreshing
These
for
laws
some
have enabled
people,
me to
but
fight for their enjoyment
to the
of a fair
extent
state
that there
in
were
our
people there
American
who were
project.
dangerous and were known to be
I stand
dangerous,
before a group of 100 United States senators who have
and
chosen
he
to serve your
encouraged
country
or stepped aside for
from
them,
all corners of this
and
great
then
nation,
patted them on the
giving
back
up
as they
all
left.
sorts of
Like, that is
professions,
an issue.
time with family, and perhaps other more lucrative opportunities to serve your country. Mr. President, you are a man who so honorably served this nation in the Senate and in public service before your tenure here. It is an honor to appear in this historic hall of democracy, yet today, that honor is tempered by an overriding feeling of grave concern. Grave concern for the danger to the institution of the presidency that I believe even convening these proceedings indicates. The joy I believed I would feel if I ever had the great privilege of appearing before this body is replaced by sadness and pain. My overriding emotion is frankly wanting to cry for what I believe these proceedings will do to our great, so long enduring, sacred Constitution and to the American people on both sides of the great divide that now characterizes our nation. Esteemed members of the Senate, going forward with this impeachment trial of a former President of the United States is unconstitutional for reasons we have set out in our brief, some of which we'll focus on here, and as a matter of policy, it is wrong, as wrong can be for all of us as a nation. We are told by those who favor having these proceedings that we have to do it for accountability. But anyone truly interested in real accountability for what happened at the Capitol on January 6th, would of course insist on waiting for a full investigation to be completed. Indeed, one is underway in earnest already, intent on getting to the bottom of what happened. Anyone interested in ensuring that it's truly the one or ones responsible from whom accountability is sought would more than willingly wait for the actual evidence, especially with new evidence coming in every day about pre-planning, about those who were involved, and about their agenda bearing no relationship to the claims made here. They say you need this trial before the nation can heal, that the nation cannot heal without it. I say our nation cannot possibly heal with it. With this trial, you will open up new and bigger wounds across the nation, for a great many Americans see this process for exactly what it is: a chance by a group of partisan politicians seeking to eliminate Donald Trump from the American political scene and seeking to disenfranchise 74 million plus American voters and those who dare to share their political beliefs and vision of America. They hated the results of the 2016 election and want to use this impeachment process to further their political agenda. These elitists have mocked them for 4 years. They've called their fellow Americans who believe in their country and their Constitution deplorables. And the latest talk is that they need to deprogram those who supported Donald Trump and the grand old party. But at the end of the day, this is not just about Donald Trump or any individual. This is about our Constitution and abusing the impeachment power for political gain. Excuse me. They tell us that we have to have this impeachment trial, such as it is, to bring about unity. But they don't want unity, And they know this so-called trial will tear the country in half, leaving tens of millions of Americans feeling left out of the nation's agenda, as dictated by one political party that now holds the power in the White House and in our national legislature. But they're proud Americans who never quit getting back up when they're down, and they don't take dictates from another party based on partisan force-feeding. This trial will tear this country apart, perhaps like we have only seen once before in our history. And to help the nation heal, we now learn
I don't think
that
that
House managers, in their wisdom,
before the
have
January
hired a movie
6th
company
thing.
and a large law firm to create, manufacture, and splice for you a package designed by experts to chill and horrify you and our fellow Americans.
And also for all the talk about the
They want to put you through a 16-hour presentation
and,
over 2 days, focusing on this as if it were some sort of blood sport.
The other party from power.
And to what end? For healing?
I mean,
for unity?
There were dozens of
accountability?
court cases to
Not
try
for
and
any of
overturn
those.
the election.
For surely they are much
I know
better ways
Trump
to achieve
characterizes
each.
it as
It is again for pure, raw,
pursuing
misguided
every legal
partisanship
avenue,
that
which
makes
is
them believe
technically true,
playing to our worst
but
instincts somehow is
it's
good.
almost like a
They don't
slap
need to show
lawsuit.
you
It's
movies
almost
to
like
show
he's
you
trying
that
to,
the riot
he was trying
happened
to
here.
punish
We will stipulate
the
that it
election
happened, and you know all
system
about it. This is a
for
process
losing.
fueled irresponsibly by base
which is
hatred
in
of these
regular
House
lawsuits
managers and those who
in
gave
most
them their
states
charge,
disallowed.
and they are willing
in
to
fact, when you
sacrifice
do
our
them,
national character
you're supposed
to
to pay
advance their
for
hatred and their fear
the legal
that
fees
one
of
day
the other party.
they might not be the party in power. They have a very different view of democracy and freedom from Justice
I find
Jackson,
it hard to reconcile an attempt to go through so
once
many
wrote,
lawsuits
but freedom to differ
and for
is not
states
limited
to interfere
things
with
that do not
other
matter much.
states'
That would be a mere shadow of freedom.
election outcomes.
The test of its substance is the right to differ
While talking
as to
about
things that touch at the heart of the
individual
existing order.
freedoms.
They
is
have
like
a very
little
different view
contradictory to me
of democracy.
I can understand if
freedom.
like there's some value there.
This is nothing less than the political
is being
weaponization
sought, right?
of the
Like
impeachment
if-
process. Pure,
if the idea
raw
is really like,
sport,
well, I
fueled
don't
by the
care
misguided
about
idea of
that
party over
rationale.
country, when in fact both
I just
will
want
surely
Trump to
suffer.
win no matter
I can
what.
promise you that if these
Like,
proceedings go
I would
forward,
appreciate
everyone
that
will
honesty,
look bad.
but I don't think that's what's
You
happening.
will see and hear many members of our
And I
Congress
think when that
saying and
point
doing
gets
things
raised,
they must
it
surely
tends
regret.
to go to
But perhaps far
something
more
like,
worse,
well,
far
that's
worse
what everybody does.
than a moment of personal shame in a
And
world
I don't
in
think
which
that's a
history
very
passes
good argument.
from our memories
I
in a
think
moment. Our
that's
great
what everybody
country,
does.
a model for all the world, will be far more divided, and our standing around the world
I mean,
will be
obviously,
badly
it's,
broken.
it's not a good argument for
Our arch
anything,
enemies who pray each and every day
it's
for our
almost like an
downfall
acceptance
will watch with glee,
of a new low.
glowing in the
right?
moment as they see you at your worst and our country in internal
Kind of like when
divide.
you
Let's be perfectly
you
clear.
go to college and
If
you start
vote
getting
to
the
proceed
freshman
with this
15,
impeachment trial,
and,
future senators will
you
recognize
just refuse
bought into
to-
a radical constitutional
to,
theory
like, buy the
that
next
departs
size up of
clearly
pants,
from the language of the Constitution itself
you're
and holds, and this
you're
is in
like
their brief,
refusing to accept that
that
that's
any
the new
civil officer
standard.
who ever dares
Whereas
to want
like
to serve
with
his or
Donald
her
Trump
country
and all of this
must
stuff,
know
it feels
that
like
they will be subject to impeachment.
everyone's like, well, let's just
long
buy
after
the
their
size
service in office has
45s.
ended,
And,
subject only to the
and
political
because like
and
everyone's a fat
landscape
cat anyway,
of the
right?
day
Like let's grow
that
into
is in
those pants. Like,
operation
I don't
at
want
any
to do
future
that. I
time.
want to like have
This
the
is exactly
denial
the position
and
taken
like
by the House managers
the hope and the
at page
aspiration
65 of their
that
brief.
like things will be better.
Unprecedented,
than this.
radical position.
And yeah,
They
there's like
unabashedly say
political
so.
footballs
Imagine
carried
the
around all
potential
the time.
consequences for civil officers
for
you know
example, the
and who
Kavanaugh
you
hearing.
believed served so honorably.
I don't want to
and who,
weigh
in
in
the
on
view
like
of a
whether
future Congress, might one day be deemed to be impeachment worthy.
any of it was
Imagine
right.
it now,
I think it was the
because
wrong forum
your
for that.
imagination is the only limitation.
Compared to this, I
The
think
House
this
managers
is the
tell
right
you
forum
a correct
for
reading
the
of the
discussion.
impeachment power under the Constitution is that it has
But
no
during the
temporal
Kavanaugh
limit
hearing,
and can reach back in
there
time
was,
without limitation to target anyone
there was
who
a
dared
lot
to serve
of
our nation as
political
a civil
rhetoric
officer.
that was designed to
Now
make
add
it
that to
seem
their
like
demand
something
that your
more
members,
was
that
known
you members
than was
put
actually known.
your imprimatur
And I don't think that's
on the
okay.
snap impeachment they returned in this case.
My vote
and
did
could
not
do
go to
again
the
in
people who
future
did that during the
if you endorse it
presidential
by
campaign
going forward
because
with
I
this
think it's
impeachment
wrong.
trial. This is an untenable combination
And I think when
that literally
someone
puts the institution of the presidency
goes into the system to like try and disrupt the system, which is like a fine goal. Like that's an okay thing. I understand.
Under theirs,
dismantle the government because you think it's broken. Like that's a reasonable thing to get behind.
Every civil officer who has served is at risk of impeachment if any given group
accuse the system that the guy ran for 8 years of being rigged against him
now deserves to be canceled.
Where more states
they've made clear in public statements that what they really want to accomplish here in the name of the Constitution is to bar Donald Trump from ever running for political office again. But this is an affront to the Constitution, no matter who they target today. It means nothing less than the denial of the right to vote and the independent right for a candidate
and I think
to
it
run
did
for
lead
elective
to
political office,
the violence at the
guaranteed
Capitol,
by the
not
First and
because he
14th
said, "Hey, let's
Amendments to the
go
United
attack
States
the Capitol,"
Constitution, under the guise of impeachment as a tool to disenfranchise.
So much discontent.
Perhaps my friend put the situation
because
simply
people
and sharply
believed him.
into
like,
focus
the
last
office
week on
of
his
the
radio
president
show.
means something.
My friend is a distinguished lawyer who served as an
when
ambassador
you go to
former
church
President
and your pastor
Obama
says
and has
something,
friends
it
among
means
you.
something.
He described
and
himself to his
think
listeners as a
disregarding
dyed-in-the-wool,
it and saying, "Well, that's just the way it is."
But he said,
is the right way to go about
idea
life.
Of 100 people in these circumstances,
I think
deciding the tens of millions of American
Republican
voters
talking
cannot
points
cast
so
their
far
vote
have
for their
been
candidate for president ever again is unthinkable
at best,
and it truly should be.
Probably
I will discuss
more
today several
about
reasons this matter
making
should not
sure
and
their
must not
voters don't
proceed.
get mad at them
Why the Senate lacks jurisdiction to
than
conduct this
anything
trial
else, than any
of a former
care
president,
about the voter themselves.
a president no longer in office and now a private citizen. Any single reason in our trial memorandum or discussed today suffices. But I want to start with a discussion of the fundamental due process lacking from the start, and that would last through the end if this goes forward, because it is this irretrievably flawed process and its product, a dangerous, snap impeachment, that brings us here and that threatens to send a message into the future that we will all regret forever.
Yeah.
And that stain this body, which up to now our founding fathers believed
I'm gonna grab
was
some
uniquely
lunch.
suited for the most difficult task of conducting an impeachment trial, as Mr. Hamilton wrote in Federalist 65. These aren't just niceties. I make no apology for demanding in your name, in the name of the Constitution, that the rights to due process guaranteed under the Constitution are adhered to in a process as serious as this in our national lives. The denial of due process in this case, of course, starts with the House of Representatives. In this unprecedented snap impeachment process, the House of Representatives denied every attribute of fundamental constitutional due process that Americans correctly have come to believe is part of what makes this country so great. How and why did that happen? It is a function of the insatiable lust for impeachment in the House for the past 4 years. Consider this.
I want to say this for Donald Trump, who I may well be voting to impeach.
Donald Trump has already done a number of things which legitimately raise the question of impeachment.
I don't respect this president, and I will fight every day until he is impeached.
That is grounds to start impeachment proceedings. Those are grounds to start impeachment. Those are grounds to start impeachment proceedings. Yes, I think that's grounds to start impeachment proceedings.
I rise today, Mr. Speaker, to call for the impeachment of the President of the United States of America.
I continue to say, impeach him! Impeach 45! Impeach 45!
So we're calling upon the House to begin impeachment hearings immediately.
On the impeachment of Donald Trump, would you vote yes or no?
I would vote yes. I would vote to impeach.
Because we're gonna go in there, we're gonna impeach the mother.
But the fact is, I introduced articles of impeachment in July of 2017.
If we don't impeach this president, he will get reelected.
My oath requires me to be for impeachment, have an impeachment hearing. He needs the scarlet eye on his chest.
The representatives should begin impeachment proceedings against this president.
It is time to bring impeachment charges against him. Bring impeachment charges.
My personal view is that he richly deserves impeachment.
I'm here at an impeachment rally, and we are ready to impeach the...
The relevant timeline in the House reveals the rush to judgment. On the day following the January 6th riot, the House leadership cynically sensed a political opportunity to score points against the outgoing then-President Trump. And the Speaker demanded that Vice President Pence invoke the 25th Amendment, threatening immediate impeachment for the President if Mr. Pence did not comply with this extraordinary and extraordinarily wrong demand. 4 days later, on January 11th, 2021, the instant article of impeachment was introduced in the House. Speaker Pelosi then gave the Vice President another ultimatum, threatening to begin impeachment proceedings within 24 hours if he did not comply. Vice President Pence rejected Speaker Pelosi's demand, favoring instead adherence to the Constitution and the best interests of the nation over a politically motivated threat. On January 12th, Speaker Pelosi announced who the 9 impeachment managers would be, and on January 13th, 2021, just days after holding a press conference to announce the launching of an inquiry, the House adopted the article of impeachment, completing the fastest impeachment inquiry in history and according President Trump no due process at all, over strong opposition based in large part on the complete lack of due process. To say there was a rush to judgment by the House would be a grave understatement. It is not as if the House members who voted to impeach were not mightily warned about the dangers to the institution of the presidency and about our system and to our system of due process. They were warned in the strongest of terms from within their own ranks, adamantly, clearly, and in no uncertain terms, not to take this dangerous snap impeachment course. Those warnings were framed in the context of the constitutional due process that was denied here. Consider the warnings given by one member during the House proceedings, pleading with the other members to accord this decision the due process the Constitution demands. This is Representative Cole of Oklahoma. With only 1 week to go in his term, the majority is asking us to consider a resolution impeaching President Trump. And they do so knowing full well that even if the House passes the resolution, the Senate will not be able to begin considering these charges until after President Trump's term ends. I can think of no action the House can take that is more likely to further divide the American people than the action we are contemplating today. Emotions are clearly running high, and political divisions have never been more apparent in my lifetime, Representative Cole said. Mr. Cole's words on the floor, emphasizing the care that must be taken with respect to the consideration of an article of impeachment, echoed the concerns by our founding fathers on this subject. Listen to this from Mr. Hamilton in Federalist number 65. Quote, "A well-constituted court for the trial of impeachments is an object not more to be desired than difficult to be obtained in a government wholly elective. The prosecution of them, for this reason, will seldom fail to agitate the passions of the whole community and to divide into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or on the other. In such cases, there will always be the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt." Prescient thinking by Mr. Hamilton, as we see often. And what I say to you is a proof of the need for due process based on the critically serious nature of the singular role the impeachment process has in our government. Mr. Hamilton characterized the consideration of an impeachment in these terms: the delicacy and magnitude of a trust which so deeply concerns the political reputation and existence of every man engaged in the administration of public affairs speak for themselves. This, too, in Federalist 65. Now back to the House and the warnings against this rush judgment in this case. Mr. Cole of Oklahoma again. In the name of healing, a path forward, he said, our people so desperately need, he warned that, quote, "The House is moving forward erratically with a truncated process that does not comport with the modern practice and that will give members no time to contemplate the serious nature of action before us." Mr. Cole emphasized to his colleagues that such care must be taken with the consideration of an article of impeachment, quote, "in order to ensure that the American people have confidence in the procedures the House is following, and because the presidency itself demands due process in the impeachment proceedings." Congressman Cole continued, "Unfortunately," this is a quote, "the majority has chosen to race to the floor with a new article of impeachment, foregoing any investigation, any committee process, or any chance for members to fully contemplate this course of action before proceeding. Mr. Cole complained that the majority is failing to provide the House with an opportunity to review all the facts which are still coming to light, to discuss all the evidence, to listen to scholars, to examine the witnesses, and to consider precedents. He's noted further, this is not the type of robust process we have followed for every modern impeachment, and the failure to do so does a great disservice to this institution and to this country, Mr. Cole said. Mr. Cole complained right on the House floor that rather than following the appropriate processes, he said the House has used in every modern impeachment, the majority is rushing to the floor, tripping all over themselves in their rush to impeach the president a second time. And in Mr. Cole's words, it was doing so to, quote, settle scores. And he warned that this snap impeachment approach would cause great division as the country looks ahead to the start of a new administration. He said to them, in a matter as grave and consequential as impeachment, shouldn't we follow the same process we've used in every modern impeachment rather than rushing to the floor? And he implored them, on behalf of generations of Americans to come, we need to think more clearly about the consequences of our action today. And Mr. Cole then reached across the aisle and credited a member of this body, Senator Manchin, with having voiced similar sentiments about how ill-advised this rushed process was, suggesting that the underlying events were a matter for the judicial system to investigate, not one for a rushed political process. Finally, Mr. Cole admonished his fellow House members, telling them, we need to recognize that we are following a flawed process. The alarm Mr. Cole sounded went unheeded. Now let us consider the process in the House that actually was due. The House managers assert in a memorandum that the House serves as a grand jury and prosecutor under the Constitution. They told you that again today. If this is accurate, then they highlight the complete failure to adhere to due process. One should not diminish the significance of impeachment's legal aspects, particularly as they relate to the formalities of the criminal justice process. It is a hybrid of the political and legal, a political process moderated by legal formalities. This is a quote, Richard Broughton. The Fifth Amendment to the United States Constitution provides, in relevant part, that no person shall be deprived of life, liberty, or property without due process of law. Supreme Court long ago recognized in Matthews versus Eldridge that at its core, due process is about what we all want, what we all have the right to demand, fundamental fairness. One scholar, Brian Owsley, has written that the impeachment process should and does include some of the basic safeguards for the accused that are observed in a criminal process, such as fairness, due process, presumption of innocence, and proportionality, basic American values. And of course, we know that the Supreme Court has recognized that due process protection attend congressional investigations. While Congress is empowered to make its own rules of proceeding, it may not make rules that ignore constitutional restraints or violate fundamental rights. While the case law is limited in terms of spelling out what due process looks like in impeachment hearings, and of course in the Nixon case, Walter, not Richard, we know that there's a great deal of leeway afforded Congress with respect to its impeachment rules. It is clear that the fundamental principles that underlie our understanding of what due process must always look like apply. In Hastings versus United States, D.C. court case, vacated on different grounds, they address the matter, clearly concluding that the due process clause applies to impeachment proceedings and that it imposes an independent constitutional constraint on how the Senate exercises its sole power to try all impeachments under Article 1, Section 3, Clause 6. Court wrote in Hastings, impeachment is an extraordinary remedy. As an essential element of our constitutional system of checks and balances, impeachment must be invoked and carried out with solemn respect and scrupulous attention to fairness. Fairness and due process must be the watchword whenever a branch of the United States government conducts a trial, whether it be in a criminal case, a civil case, or a case of impeachment. A 1974 Department of Justice memo suggested the same view, opining that, quote, whether or not capable of judicial enforcement, due process standards would seem to be relevant to the manner of conducting an impeachment proceeding. More specifically, as the Hastings Court described it, one of the key principles that lies at the heart of our constitutional democracy. Again, fairness. The Supreme Court's precedents establish the general rule that individuals must receive notice and an opportunity to be heard before the government deprives them of a constitutionally protected interest. It is also true that in any proceeding that may lead to deprivation of a protected interest, it requires fair procedures commensurate with the interests at stake. Impeachment proceedings plainly involve deprivations of property and liberty interests protected by the Due Process Clause. And the House surely seeks to strip Donald Trump of his most highly cherished constitutional rights, including the right to be eligible to hold public office again, should he so choose. Due process must apply, and at a minimum, due process in the impeachment process must include that the evidence must be disclosed to the accused, and the accused must be permitted an opportunity to test and confront the evidence, particularly through the rights to confront and cross-examine witnesses, which have long been recognized as essential to due process. In almost every setting where important decisions turn on questions of fact, due process requires an opportunity to confront.
I know. And then on top of that,
it is unfathomable.
Where was this argument while
the framers, steeped in the history of Anglo-American jurisprudence,
about election fraud,
would create a system that would allow the chief executive and commander-in-chief of the armed forces to be impeached based on a process that developed evidence without providing any of the elementary procedures that the common law developed over centuries for ensuring the proper testing of evidence in an adversarial process. We would never countenance such a system in this country. Current members of the House and Senate leadership are themselves on record repeatedly confirming these procedural due process requirements. Indeed, Congressman Nadler is on record asserting that in the context of a House impeachment investigation, due process includes, quote, the right to be informed of the law, of the charges against you, to call your own witnesses, and to have the assistance of counsel. Then President Trump was not given any semblance of the due process Congressman Nadler clearly believes he deserves, based on the congressman's description of due process that must be afforded to an accused in an impeachment proceeding, as reflected in a statement he made relating to another impeachment in 1998. No reason was found for the apparent change in the congressman's point of view with respect to the two objects of the impeachment at issue.
Maggie just said
these fundamental attributes of due process have been honored as required parts of modern impeachment protocol since at least 1870. It's not seriously debatable, nor should it be, by any American legislator. In spite of all this, the House leadership defied all the norms and denied the then president all of his basic and constitutionally protected rights. For then President Donald Trump, the House impeachment procedure lacked any semblance of due process whatever. It simply cannot be credibly argued to the country, and we do not make special rules for different targets. It's the very integrity of the institution that suffers when we do, and that is what the House leadership knowingly has caused. A review of the House record reveals that the Speaker streamlined the impeachment process. House Resolution 24 to go straight to the floor for a 2-hour debate and a vote without the ability for amendments. The House record reflects no committee hearing, no witnesses, no presentation, or cross-examination of evidence, and no opportunity for the accused to respond or even have counsel present to object.
Or whatever.
As the New York Times recently reported, there were no witness interviews, no hearings, no committee debates, and no real additional fact-finding. House managers claim the need for impeachment was so urgent
Tea Party thing.
they had to rush the proceedings.
I think this is a wave of sentiment that needs to be accounted for in future elections, and we'll no longer. It's not going to be like a.
But that claim is belied.
He's not a permanent fixture. He's just somebody kicked off some new
The House leadership
thing
unilaterally and by choice waited another 12 days to deliver the article to this Senate to begin the trial process. In other words, the House leadership spent more time holding the adopted article than it did on the whole process leading up to the adoption of the article. That intentional delay, designed to avoid having the trial begin while Mr. Trump was still president, led to yet another egregious denial of due process. Excuse me. Article 1, Section 3 of our Clause 6 of our Constitution, of course, provides in pertinent part that the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation, and when the President of the United States is tried, the Chief Justice shall preside. By intentionally waiting until President Trump's term of office expired before delivering the article of impeachment to the Senate to initiate trial proceedings, Speaker Pelosi deprived then-President Trump of the express constitutional right and the right under the Senate's own Rule 4 to have the Chief Justice of the United States preside over his trial and wield the considerable power provided for in the rules of procedure and practice in the Senate when sitting on impeachment trials. That power includes, under Rule 5, the presiding officer's exclusive right to make and issue all orders, under Rule 7, to make all evidentiary orders, subject to objections by a member of the Senate. We say respectfully that this intentional delay by Speaker Pelosi, such that in the intervening period President Trump became private citizen, Mr. Trump, constitutes a lapse or waiver of jurisdiction here.
Okay.
For Mr. Trump no longer is the President, described as subject to impeachment in Article 1, Section 3, Clause 6, and in Article 2, Section 4. And this body, therefore, has no jurisdiction as a function of that additional due process violation by Speaker Pelosi. Moreover, with all due respect, then President Trump suffered a tangible detriment from Speaker Pelosi's actions, which violates not only his rights to due process of law, but also his express constitutional right to have the Chief Justice preside. That tangible detriment includes the loss of the right to a conflict-free, impartial presiding officer, with all due respect, the very purpose behind requiring the Chief Justice to preside over the President's impeachment trial, along with the other benefits of having the two branches combined, the Chief Justice from the judiciary and the Senate, for the impeachment trial of the President, reflected in Federalist 66. One of the reasons the Chief Justice was chosen for that task. Mr. Trump now faces a situation in which the presiding officer will serve as both judge, with all the powers that the rules endow him with, and juror with a vote. And beyond that, the presiding officer, although enjoying a lifelong honorable reputation, of course, has been Mr. Trump's vocal and adamant opponent throughout the Trump administration, and in fact, in the very matter on trial, the presiding officer respectfully already has publicly announced his fixed view before hearing any argument or evidence that Mr. Trump must be convicted on the article of impeachment before the Senate, and indeed that members in both parties have an obligation to vote to convict as well. Nowhere in this great country would any American, and certainly not this honorable presiding officer, consider this scenario to be consistent with any stretch of the American concept of due process and a fair trial, and certainly not even the appearance of either. By no stretch of the imagination
but if they've already
could any
decided,
fair-minded
like, why
American
then do the fact
be confident
finding?
that a trial so conducted
They're arguing
would
for the witnesses,
or could
right?
be the fair trial promised by the leader. While most procedural aspects of a Senate impeachment trial may be non-justiciable political questions, this is not an excuse to ignore what law and precedent clearly require. The present situation either presents a violation of the constitutional text found in the articles mentioned above that require the Chief Justice to preside when the President is on trial, or it is a clear denial of due process and fair trial rights for private citizen Trump to face an impeachment trial so conducted by the Senate.
It sort of is.
The impeachment article should be treated as a nullity and dismissed based on the total lack of due process in the House. It should be dismissed because of Speaker Pelosi's intentional abandonment or waiver of jurisdiction, if the House ever acquired jurisdiction. And the article should be dismissed because the trial in the Senate of a private citizen is not permitted, let alone with the conflicts just described that attend this proceeding. Finally, on the subject of due process in this matter, I say the following. This is our nation's sacred Constitution. It has served us well since it was written, and it's been amended only through a careful process. It is a document unique in all the world. It is a foundational part of what makes the United States a beacon of light among the other nations of the world. It not only has room for a tremendous variety of perspectives on the philosophical and political direction our country should take, it encourages the advocacy of our differences. But we have long held that fundamental to its health and well-being, and therefore to ours as a nation, is its insistence on due process for every citizen. The emphasis on the right to due process long ago was recognized as its life breath, a primary guarantor of its eternal viability as our political, civic, and national guiding light. We all well know that there are many systems in other countries around the world that do not offer any semblance of the safeguards our constitutional concept of due process provides. Some of them have chosen their own handbooks, which direct their citizens' conduct on penalty of death. This is one of them. There can be no room for due process in such a system as this, or the system would be lost. Snap decisions are required in a system like this to maintain power for one political philosophy over all others in those kinds of systems. But we as a nation have rejected those systems and the kind of snap decisions they demand to maintain control for one party, for one point of view, and for an imposed way of life. We choose to live freely under a constitution that guarantees our freedom. Other countries fear those freedoms and seek to ensure adherence to a party line.
That might have done it. Check.
Snap decisions that remove political figures of the norm, maintaining their systems. That is not our way in America. Never must be. We choose in America to live by our Constitution and its tenets. The due process does not be by putting your imprimatur
on the snap judgment made in this matter to impeach the President of the United States without any semblance of due process at every step along the way, puts the office of the President of the United States at risk every single day. It is far too dangerous a proposition to countenance, and you must resoundingly reject it by sending the message now that this proceeding, lacking due process from start to finish, must end now with your vote that you lack jurisdiction to conduct an impeachment trial for a former president whose term in office has expired and who is now a private citizen. So one reason you must send this message here and now is because of the complete lack of due process that brought this article of impeachment before this body. God forbid we should ever lower our vigilance to the principle of due process. An impeachment trial of a private citizen Trump held before the Senate would be nothing more nor less than the trial of a private citizen by a legislative body. An impeachment trial by the Senate of a private citizen violates Article 1, Section 9 of the United States Constitution, which provides that no bill of attainder shall be passed. The bill of attainder, as this clause is known, prohibits Congress from enacting a law that legislatively determines guilt and inflicts punishment upon an identifiable individual without provision of the protections of a judicial trial. A bill of attainder is a legislative act which inflicts punishment without a judicial trial. A judicial trial. The distinguishing characteristic of a bill of attainder is the substitution of a legislative determination of guilt and legislative imposition of punishment for judicial finding and sentence. The bill of attainder clause in the separation of powers doctrine generally reflects the framers' concern that trial by a legislature lacks the safeguards necessary to prevent the abuse of power. As the Supreme Court explained in United States versus Brown, the best available evidence, the writings of the architects of our constitutional system, indicate that the bill of attainder clause was intended not as a narrow, technical, and therefore soon-to-be outmoded prohibition, but rather as an implementation of the separation of powers, a general safeguard against legislative exercise of the judicial function. More simply, trial by legislature. The Bill of Attainder reflected the framers' belief that the legislative branch was not so well suited as politically independent judges and juries. When the Senate undertakes an impeachment trial of a private citizen, as it clearly understands to be the case here, supported by the facts that the Chief Justice is not providing and Mr. Trump is not the president, it is acting as a judge and jury rather than a legislative body. And this is exactly the type of situation that the Bill of Attainder constitutional provision was meant to preclude. It is clear that disqualification from holding future office, the punishment the House managers intend to seek here, is a kind of punishment, like a banishment and others, that is subject to the constitutional prohibition against the passage of bills of attainder, under which general designation bills of pains and penalties are included. The cases include Cummings, Ex parte Garland, and this Brown case. The Supreme Court 3 times has struck down provisions that precluded support of the South or support of communism from holding certain jobs as being in violation of this prohibition. Thus, the impeachment of a private citizen in order to disqualify them from holding office is an unconstitutional act constituting a bill of attainder. Moreover, this is the exact type of situation in which the fear would be great that some members of the Senate might be susceptible to acting in the haste the House acted in when it rushed through the article of impeachment in less than 48 hours, acting hastily simply to appease the popular clamor of their political base, the very kind of concern expressed by Mr. Hamilton in Federalist 65. Moreover, as Chief Justice Marshall warned in Fletcher versus Peck, it is not to be disguised that the framers of the Constitution viewed with some apprehension the violent acts which might grow out of the feelings of the moment, and that the people of the United States, in adopting that instrument, have manifested a determination to shield themselves and their property from the effects of those sudden and strong passions to which men and women are exposed. The restrictions on the legislative power of the states are obviously founded in this sentiment, and the Constitution of the United States contains what may be deemed a Bill of Rights for the people of each state. No state shall pass any bill of attainder in this form. The power of the legislature over the lives and fortunes of individuals is expressly restrained. And so now let's turn to the text of the Constitution. Turning to the text of the Constitution is, for many, of course, the most appropriate and the most important starting place for trying to answer a Constitution-based question. There are several passages of the United States Constitution that relate to the federal impeachment process. Let's turn to a reading of the text now. A true textual analysis, as the name implies, always begins with the words of the text and only resorts to legislative history, or history itself, if the meaning of the text is not plain. As the Supreme Court has emphasized, statutory interpretation, as we always say, begins with the text. In interpreting the text, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary, as distinguished from technical, meaning. And we must enforce plain and unambiguous statutory language according to its terms. If the President is impeached, the unambiguous text of the Constitution commands that the Chief Justice of the United States shall preside, as we discussed earlier. Again, the Chief Justice is disinterested and nonpartisan. His presence brings dignity and solemnity to such a proceeding. In this case, the Chief Justice clearly is not presiding, and the conflict of interest wouldn't necessarily just arise as a substitute for the Vice President. It's the appearance of a conflict of interest and a conflict of interest and the prejudgment that we've discussed. In this case, as we say, the Chief Justice clearly is not presiding. The Senate President pro temp is presiding. It appears that in the leader's view, undoubtedly joined by other senators, this is permitted by the Constitution because the subject of the trial
is he making the argument that this impeachment trial is itself a bill of attainder?
That for constitutional purposes of the trial, the accused is a non-president.
Okay.
The role of the Senate, though, is to decide whether or not to convict and thereby trigger the application of Article 2, Section 4.
Because if he is,
the President,
I'm just going to say,
Vice President, and all civil
every
officers
impeachment,
of the
like
United
by the
States,
definition of a bill of attainder, every impeachment trial
conviction of
is,
treason,
if you're going to define it that way,
treason, bribery.
Okay, so the Supreme Court says that a bill of attainder is basically when you declare people criminals without the benefit of the judicial trial. And the court says, the Supreme Court has said in the past, that a bill of attainder occurs when the legislature specifically identifies the people to be punished, imposes the punishment, and does so without the benefit of the judicial trial.
Does not impact the constitutional validity of this trial.
Exactly, yeah, that's exactly what the Constitution says you should do in an impeachment proceeding.
Development so significant.
I don't really see what point he's making here. Like, everyone's treating it like it's a criminal proceeding. Again, we're not taking away, like, if he's convicted, which he probably won't be given the votes, but like, if he's convicted in this trial, he's not going to jail. His freedom is not being taken away. The sole penalty imposed is that he cannot run again for a United States office. He could run for governor of Georgia or whatever. I mean,
that a term appearing
it's not, I think people are treating it. Yeah, he's losing a privilege,
the same way each time
makes
it
sense. Like,
this presumption
we should be holding our representatives to a higher
when a
standard
term is
than
repeated
the
within a
person.
given sentence.
But
Additionally,
anyway, I'm just
the court in at least one instance
Don't mind me.
has referred to a broader, quote, established canon that similar language contained within the section of a statute be accorded a consistent meaning. I know this is a lot to listen to at once, a lot of words, but
I swear that means
that words are what make our Constitution, quite frankly, and the interpretation of that Constitution, as you well know, a product of words. If the text, quote, the President of the United States in the constitutional provision requiring the Chief Justice to preside can refer only to the sitting president and not to former presidents, then the textual identification of the President contained in Article 2, Section 4, which makes the President amenable to impeachment in the first place, also excludes anyone other than the sitting President. In full, that sentence provides that, quote, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. This is the substantive phrase of the Constitution vesting the conviction and removal power in the Senate, and it contains a clear jurisdictional limitation. The House managers do understand what the word president means for purposes of other constitutional provisions, and so they should understand this limitation as well. Only a sitting president is referred to as the President of the United States in the Constitution, and only a sitting president may be impeached, convicted, and removed upon a trial in the Senate. The President in Article 2, Section 4, and the President in Article 1, Section 3 identify the same person. If the accused is not the President in one, he is not the President in the other. No sound textual interpretation, I emphasize textual, no sound textual interpretation principle permits a contrary reading. In the words of the Supreme Court, it is a normal rule of statutory construction that identical words used in different parts of the same act are intended to have the same meaning. Unwittingly or unwillingly, as it may be, Senate Democrats in their announcement.
I wonder if he believes that privacy rights aren't
already
real.
Taken their position on this matter.
Because by
the accused is not the President. The text of the United States Constitution, therefore, does not vest the Senate with the power to try him and remove him. A factual
I think most of
Trump
supporters
or disqualify him a legal
how this guy can
as if he were the President.
Well, I do understand.
House managers contend the Senate has jurisdiction over this impeachment because despite the fact that he's no longer the President, the conduct that the former President is charged occurred while he was still in office.
Strict
that argument does not in any way alter
when
the Constitution's
convenient.
clear textual identification of the President. House managers justify their strained argument by noting that the Constitution's impeachment provisions are properly understood by reference to this overarching constitutional plan. But with that very justification in mind, their argument fails once again. In an impeachment, it is the accused's office that permits the impeachment. Ceasing to hold that office terminates the possibility.
So if you want to commit a crime as a
private
federal
person may not be impeached in America. And so they ask you to look back at the British model. The Constitution, as I say, does not make private citizens subject to impeachment.
Yeah.
The founders rejected the British model that allowed Parliament to impeach anyone except for
if that were the case,
and so they limited impeachment.
It's not like the Constitution doesn't provide other penalties besides removal from office. It says that you must remove them from office if they're in office, And then
his
you have
removal.
the discretion
Article 2,
to
Section
impose
4,
the
straightforward rule. Whenever a
preventing
civil
them
officer
from
is
running
impeached
again.
and convicted for high crimes and misdemeanors, they shall be removed. It is undeniable that in this instance, removal is moot in every possible
Right, so
regard.
let's move on to the other
Removal
penalties.
is a factual and legal impossibility. Yet the article of impeachment itself, read it, in the wherefore clause, it calls for removal. This is one reason why impeachment proceedings are different from ordinary trials, and why the Constitution pointedly separates the two. In ordinary criminal jurisprudence, a person convicted of public crimes while he or she was in office may still be punished even though they no longer hold that
In
office.
ordinary criminal jurisprudence.
Not so with impeachment.
Yeah.
In a Senate impeachment trial, conviction
argument.
means
Sir,
and
you can't
requires
rely on
removal.
laws,
And
arguments.
conviction without a removal is no conviction at all.
Lying.
Only upon a valid
Right,
conviction
right.
and its requisite.
So if you go to court,
enforceable
you don't
removal
claim
may the additional judgment
some right
disqualification
under law.
plausibly be
Can't
entertained.
later
Presidents
go
are
on
impeachable
and say,
Claim it.
because
Yeah.
presidents are
So
removable.
under criminal
Former
jurisprudence,
presidents are
they
not,
just
because they cannot
didn't
be
raise
removed.
this question.
The Constitution
They're not actually
trial
answering
by
the
the
question
Senate
of
sitting
whether
on
it's
the Court of
within
Impeachment is reserved for the President of the United States, not a private citizen who used to be
letting
President of the
it
United
happen.
States. Just as clear, the judgment required
That
of
they're
conviction
opting
is
to
removal
raise
from
the
office.
To raise the
So
argument.
if you're going to rely
Will
totally
no longer
on
be removed.
Right.
that's
The purpose,
Right.
text, and structure of the Constitution impeachment
And in
clauses
fact,
confirm this
isn't the
intuitive
reason, or
and
at least
common
the
sense
speculated reason,
understanding.
I don't know
So
how
wrote
true it is,
Judge Michael
that
Luddig,
Trump's
former
legal
judge in the
team
United
stepped
States Court of
down
Appeals
a couple of weeks
for the
ago
Fourth
was
Circuit.
because he was in fact insisting that they
And
continue
indeed,
to make
there are
arguments
state
based on
court
election
decisions
fraud
that analyze this very
rather
same
than
language
make
and
this
conclude
jurisdictional
that
argument,
impeachment
which
can only
is
be
better. But
entertained
yeah, as
against
Alex
an
said,
existing
it's not,
officer subject to removal.
yeah, it's not
Read State versus
something you'd
Hill
be able to rely on
from
in
Nebraska
court if you didn't raise it
and
at
Smith
the beginning.
versus Brantley, 1981 decision from the Florida Supreme Court.
Okay.
This is the first time that the United States Senate has ever been asked to apply the Constitution's textual identification of the President in the impeachment provisions to anyone other than the sitting President of the United States. And of course, most significantly from a textual approach, the term specifically used is the President, not a President. And there can be only one President, the incumbent at a time. Judge Luddig relies on this textual reading for his firm conclusion that a former president cannot be impeached or convicted. Consider the alternative, as Robert Delahunty, Professor John Yoo have. If Mr. Trump can be convicted as the president, the language the Constitution uses, then why is he not still the president under the Commander-in-Chief Clause, for example? They are joined by Professor Alan Dershowitz and University of Chicago Professor Richard Epstein in their focus and conclusion. They point out the dangers of an approach that deviates from a focus on the text, if there is no temporal limitation. That's what they've suggested to you. Remember, you can go back in time and impeach any civil officer who ever served for anything that occurred during the course of their service.
What he's not
Time
mentioning
immemorial.
here is that in order for that to be true, that
With the House
person would
manager's
have to be
position, the concept
impeached while in
necessarily includes
office.
all
And
former
impeachment
executive
is the
officers and
process of
judges,
actually bringing
including
the
perhaps the
charges.
impeachment now of Jimmy Carter for his
As
handling of the
Trump
Iran
was
hostage
impeached
scandal
while he
is
was
one
still
example.
in office.
That
And
flows
only the
logically
trial would
from their
occur
argument,
later. He is
without
making
any
it sound
hesitation.
like holding this
Further, they
trial
ask,
creates
why
much
not then
more
countenance
of
a
a
broad
break with
reading of other
precedent than it
terms?
actually
When I say
does.
they ask, I mean
So,
these, experts who've opined
if it
on
were
this.
the case that Trump hadn't been impeached,
Why not then countenance a broad reading of
in
other
his
terms,
last
such
couple
as
weeks
terms
as
like
president,
high crimes and misdemeanors,
and then we were
however
impeaching him
broadly
now and then
construed,
holding a
are
trial,
intended to be exclusively the
that
only
would,
kind of conduct
that
intended
would
as
be
impeachable.
much more of a problem.
They conclude, these
and a
experts, that by
conflict
writing
with
that
the
a
constitutional
non-textual impeachment power
language.
would undermine the
But it's
Constitution's
not as
effort
though
to make the president
doing
independent
this
of Congress,
sets the
a
precedent that in
central
the
goal
future
of the founding fathers.
politicians can just
The
go
authors
after
convincingly
anyone. The
argue for
impeachment
textual
itself needs to
analysis
happen
over non-textual
while
analysis,
the
over
representative
non-textual
is in
reliance on a
office.
presentation of history, suggesting that if one's presentation of history were to control, it would expressly permit conduct
Which makes
contrary
sense.
to the
I mean, there
express
should
language,
be a limit,
leading to clearly
but
unintended results. And I must tell you that I've spoken
think
to
he's-
Judge Ken
he's,
Starr
muddying
at
the
some length
waters
over
a
this
little
past
bit.
week about this, and this textual approach is something he too feels very strongly about. I also happen to be friendly with Chuck Cooper, by the way, who's a fine person. Also happens to be a person who has a strong animus against President Trump. But Chuck Cooper is a fine lawyer and a fine person, as I'm sure our friends from Alabama, no. As we already have discussed, the risks to the institution of the presidency and to any and all past officers is limited only by one's imagination. The weakness of the House manager's case is further demonstrated by their reliance on the unproven assertion that if President Trump is not impeached, future officers who are impeached will evade removal by resigning, either before impeachment or Senate trial. For example, they contend, citing various law professors, that, quote, any official who betrayed the public trust and was impeached could avoid accountability simply by resigning 1 minute before the Senate's final conviction vote. This argument is a complete canard. The Constitution expressly provides in Article 1, Section 3, Clause 7, that a convicted party following impeachment shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law after removal. Clearly, a former civil officer who's not impeached is subject to the same. We have a judicial process in this country. We have an investigative process in this country to which no former office holder is immune. That's the process that should be running its course. That's the process the Bill of Attainder tells us is the appropriate one for investigation, prosecution, and punishment, with all of the attributes that branch. We're missing it by 2 articles here, that the Article 3 courts provide. They provide that kind of appropriate adjudication. That's accountability. There are appropriate mechanisms in place for full and meaningful accountability, not through the legislature, which does not and cannot offer the safeguards of the judicial system which every private citizen is constitutionally entitled.
He's not going to prison as a result of the
More to the point here, their argument does nothing to empower a different reading of the Constitution's plain text. That is, one that reads the president in one provision to include former presidents, but reads the president in the other provision to mean only the sitting president. Second, this red herring of an argument also fails because the former president did not resign, even amid calls by his opponents that he do so. As a result, the Senate need not decide whether it possesses the power or jurisdiction to try and convict a former president who resigned, or how it might best proceed to effectuate justice in such a case. That's not this case. The plain meaning of the Constitution's text, faithfully and consistently applied, should govern whether the United States Senate is vested by the Constitution with the power to convict a private citizen of the United States. It is not. The House managers posit in their trial memorandum that despite the fact that the primary and only necessary remedy upon conviction, removal, is a legal nullity, this late impeachment trial is appropriate because the other, secondary, optional remedy that the Senate is not even required to consider and which only takes effect upon a later separate vote, disqualification from future office, can still theoretically be applied to a former president. The managers contend Article 2, Section 4 states a straightforward rule. Whenever a civil officer is impeached and convicted for high crimes and misdemeanors, they shall be removed. Absolutely nothing about this rule implies, let alone requires, that former officials who can still face disqualification are immune from impeachment and conviction. That's what they say. I told you that today. In other words, so the argument goes, a president no longer holding office does not moot the entirety of remedies afforded by impeachment. This, however, also flies in the face of both the plain meaning of the text and the canons of statutory interpretation. First of all, the managers once again simply choose to ignore the text. Even in the passage that the managers cite, the word shall does, to put it mildly, imply a requirement. An imperative such that an impeachment in which removal would be impossible is invalid. Shall means shall. The Supreme Court has made clear that when a statute uses the word shall, Congress has imposed a mandatory duty
what
upon
he's
the
saying
subject
is
of
true.
the command,
Shall
should
remove. Be read,
Indeed, the mandatory shall
However,
normally
there's
creates
no
an obligation
problem with
impervious
reading
to
this
judicial
text
discretion.
That when an impeachment trial is
And
held for a sitting in trial conviction,
wherever
shall
the
result
Constitution
in their removal
commands,
from office.
discretion
It doesn't
terminates.
preclude
Shall
a
means
proceeding against
mandatory,
someone who
and
is
shall be
impeached,
removed
again,
is not
while in
possible
office,
for a former
but whose
officer
trial takes
no
place
longer in
after,
office.
at which point the
Impeachment
removal
cannot
from
apply.
office,
Here's
the
the and
mandatory
argument.
removal
You may
from
have
office
read about
provision
if you
is
follow
law.
such things. This is another one Judge Starr is big on, and many of the textual scholars have written about. Managers critically ignore this language in Article 1, Section 3, Clause 7, which states that judgment in cases of impeachment shall not extend further than to removal from office and disqualification, from office, comma, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Ordinarily, as in everyday English, use of the conjunctive and in a list means that all of the listed requirements must be satisfied, while use of the disjunctive or means that only one of the listed requirements needs to be satisfied. Judge Kenneth Starr subscribes strongly to this argument.
Confusing here and
understands the comma to provide further support for the reading. Judge
he's
Michael
right
Ludwig
that
again
and is
recently
sort of
argued
inclusive,
the Constitution links the impeachment remedy of disqualification
but what
from
that
future
line
office
is saying
with the remedy of removal
the
from
remedy
the
shall
office that
extend
person
no
currently
further than
occupies.
the
The
set of
former remedy
options.
does
Then
not
these are
apply
the two set
in
of
situations
options.
where the latter
this
is unavailable.
And this.
Conviction
So
and removal
again,
are
I don't think it's a very
inextricably
persuasive
intertwined.
argument
If
that
removal
just
no longer is
because
possible, neither is an
he's not
impeachment
able to be
conviction.
removed from
Judge
office at
Ludwig's
this
view is
point,
consistent with
that
that
should
of
prevent the
Joseph
Senate
Story,
from
Justice
using their
Joseph Story,
discretion to
in his
impose a
famous
different
commentaries
penalty,
on the Constitution,
simply because of
wherein
the
Story,
word
Justice
and is
Story analyzed
appropriate there.
impeachment
Actually.
is inapplicable
In
to
fact,
officials who
if
have left
or
their position
were used,
because removal, a primary remedy,
you'd have
that
to
the
read it
impeachment
as saying you
process
can only
authorizes
do
is
one
no
or the
longer
other.
necessary. Judge Story,
Which
Justice Story noted
is
that he was not,
nonsense because
going to,
if you choose
posit on
to
this,
take someone
this-
out,
this
or
is his
if you,
belief,
if
and
the
this is his
Constitution
thought
requires that you remove someone from office
There's also much force in the
when
remark
they've been
that
convicted
an
in an
impeachment is a
impeachment
proceeding
trial,
purely of a political nature. It is not so
you
much
shouldn't
designed to punish an offender
you
as to
shouldn't
secure
that
the
shouldn't
state
preclude
against
you
gross official
from
misdemeanors.
also preventing them
It touches
from
neither his
future
person nor
office.
his property,
So
but simply
it has to
divests
be
him
and
of
in
his
this
political
situation, not
capacity.
or, and it doesn't really support his
Professor
argument.
Philip Bobbitt. Now, this
He was
is I have
making
to
a
say
really
this is
silly
essential.
textual argument.
We heard earlier today. We don't cite any.
Yeah, so he was
scholars.
saying that
Professor Philip Bobbitt
there's
is
a
a
line
distinguished Wexler
in,
professor at Columbia University,
I'm forgetting now,
who,
but
along with
there's
Professor
a line
Charles
that
Black,
says
wrote
remedies
the
in
handbook
case of
on
conviction
impeachment,
and
used for many, many years.
can extend
He is
no
a constitutional
further than,
expert on impeachment.
removal from office.
He has written
and,
that there is little discussion in the historical record
disqualification
surrounding
from
the precise
future
question
office.
of
And
whether
he
a
was saying that
person no
because
longer a
the
civil
word
officer
"and" is
can be
used,
impeached. And in light of the clarity of the text,
if you can't
this is
have
hardly
one of them, you
surprising,
can't do either.
Professor Bobbitt wrote. Professor Bobbitt,
But what I
by
was
the
saying
way,
is
who
like
has
you
a rich
have to use
family
and
history in the
there because
Democratic
it's saying
Party,
like you can't do any more than these two things, and these are the two
also
things.
asserted
And
the
if you put
following,
or
as
there,
recently as
it would
January
actually mean you could
27,
only do one or the
2021,
other.
arguing
Which would
against
be
holding
nonsense
this trial.
because the Constitution
He said,
actually
quote,
says you have
"There is
to
no
do the first
authority
and you can
granted
do
to
the second
Congress
if you want."
to impeach and convict persons who are not civil officers of the United States. It's as simple as that. But simplicity doesn't mean unimportance," Professor Bobbitt wrote. "Limiting Congress to its specified powers is a crucial element in the central idea of the United States Constitution, putting the state under law." Professor Bobbitt and former Stanford University law professor Richard Danzig have remarked that impeachment's principal purpose, as the 66th of the Federalist Papers makes clear, is to check the encroachments of the executive. Trial by jury, rules of evidence, and other safeguards are put aside.
Speaking of jurisprudence, the Federalist Papers have no authority here.
Similarly, yesterday.
Yeah, I guess if you're an
Professor
originalist, you might use it. You might use them to show what it was understood to mean at the time.
Remove all
Yeah, but he's going
of the United
textual.
States. That
Right?
is,
Is he?
people
Well,
holding
what's
a
that
government
and
position.
thing, right?
In the
Well,
case
you
of
can
Mr.
use
Trump,
both. You don't
the
have
House
to
is
use
reading the
one or the
Constitution
other.
as if it
And
said
in
the
fact, a lot of
process
originalists
applies
do use
to all
textualist
civil officers
arguments.
of the United States
But
and people who aren't civil officers.
yeah, it's true.
but
The Federalist
once were.
Papers are not binding
Exactly
authority.
what it does not say.
What I was gonna say is like when you make like specious arguments like this, like it takes like a particular type of person to be able to get up there and make this argument with a straight face.
The House managers.
I don't know.
A lawyer.
A politician, a lawyer. Yeah, a lawyer, I guess.
I'd like to draw your attention to page 37. This is a substantive misrepresentation to you, I would
Yeah, but
respectfully
it's
suggest.
different, I think.
And it
I don't know.
reflects
Maybe
to
I'm
me
like
a
splitting
very
hairs, but
different
this guy's
view
a representative
democracy,
of
the fear of
citizens.
democracy.
He's not being hired to
They wrote
defend
on
Trump,
page 37 of the
right?
brief
Like when you're a lawyer,
that the
you
framers,
have an
I'm
obligation to your
paraphrasing the
client.
first
He has
part,
no
the framers
obligation to
themselves
Trump.
would not have hesitated
He's
to
just
convict on
he's
these
just
facts.
endearing
Their
himself to a
worldview,
particular
this is a quote now, was
constituency.
shaped by a study of classical history as well as a lived experience of resistance and resolution. They were aware of the danger posed by opportunists who incited mobs to violence for political gain. They drafted the Constitution to avoid such thuggery, which they associated with the threat of civil disorder and early assumption of power by a dictator. The citation is 178, Bernard Bailyn, The Ideological Origins of the American Revolution. That's this book. Professor Bailyn, when he gave this description of the threat of civil disorder and the early assumption of power by a dictator and thuggery, was referring to early colonists' view toward democracy. They feared democracy. That's what they call thuggery. Democracy, because it's an elitist point of view, an elitist political point of view. We don't fear democracy, we embrace it.
You know what's funny about that? I remember when I was younger, my dad explaining why my family were Republicans.
The singular goal of the House managers
and he was saying that we don't believe in just pure democracy. We believe in representative
is to use these proceedings to disenfranchise at least
so
74 million Americans with whom they viscerally disagree, and to ensure that neither they
I know my dad's not
ever
representative
again
of every Republican
can cast a vote
world,
for Donald Trump. And if they convince you to go forward, their ultimate hope is that this will be a shot across the bow of any other candidate for public office who would dare to take up a political message that is very different from their own political point of view as the direction in which they wish to take our country. Under our Constitution,
an accusation of fraud is not the same as holding a political view. It's not a political view, it's a matter of fact.
Right.
And he's the one who actually was in power when the election was held.
Unless a strong
right.
So I don't know how he befuddled himself,
before we close
right.
but somehow he
and
did.
This is like a little outside the scope of
because
the
of the way in which our
impeachment,
nation is now divided. We must learn from his
when
triumphs.
all of the like
He had a
claims
simple
about
important message about the paramount
fraudulent
importance
votes
of
and
doing
all of
what is
that were
right.
circulating,
Mr.
like
Lincoln
Alex,
said,
you remember
stand
that
with
I was
anybody
like, where
that
are these
stands right.
starting?
Stand with
Because
him when he
usually
is
when
right,
there's like
and part with him
misinformation,
when he
I don't
does
know.
wrong.
I tend to
In
feel
both
better
cases,
when I
you
can
are
like
right.
find out
In
what
both
went
cases,
wrong in
you
the game
oppose
of
the dangerous
telephone,
extreme.
right? Like
In both cases,
there was
you
some
stand on
kernel
moral
of truth
ground and hold
that
the
got
ship
like super
level and steady.
warped.
In both,
But
you are
with this, I
national
could not
and nothing
find
less
any.
than
Because it
national.
started
The
months
second
before
message
the election
from
Yeah,
happened.
there was
favorite
no
poets.
real.
He
There
just
was
kept saying.
he just kept saying it and
Yeah.
made it
Time fraught
real.
with division and risk for
What's her
even
name?
more.
Marilyn.
The message from that other
Whatever,
time of
the
division is
manifestation
a call
lady.
for hope.
Marjorie.
And you
Oh,
bring
Marianne
strength.
Williamson.
Marianne
Special meeting today.
Williamson should
Poe
like be
Longfellow
very
wrote,
proud of Trump for just like
He
making
manifested.
this nonsense a reality by saying it enough.
But he doesn't believe in the power of love, Maggie.
Through the wind and wave, right onward steer.
Well, he's
moistened
just
eye,
not saying the
trembling
right
lip,
thing,
not
but
the
he's
signs
doing
of
the
doubt or
right
fear.
thing. He's doing the right
Sail forth into the sea of
process.
life, O gentle, loving, trusting wife, and safe from all adversity upon the bosom of that sea, thy comings and thy goings be. For gentleness and love and trust prevail o'er angry wave and gust, and in the wreck of noble lives, something immortal still survives. Thou too sail on, O
does
ship of
anyone
state,
think
sail
that
on, O
Trump
Union,
actually
strong and great.
cares about,
Humanity with all
like,
its fears,
the
with all the
integrity
hopes
of the electoral
future years,
process?
is hanging breathless on thy
I think
feet.
again, I
We
think
know
the
what
go-to
master laid thy
thing
keel, what
is
workman
that
wrought
they
thy
don't
hands
care
steel, who make each
at
mast
all who
and
he
sail and rope,
is.
what anvils
I mean,
rang,
some
what
people
hammers
like
wrought.
him, right? But
In
like
what a forge and what a
people
heat were shaped the angers
who
of
you're
thy
talking
heart.
to
Fear
about
not each sudden
about that are gonna say, I
sound
don't
and shock.
care who Trump is.
Tis
I
of the
care
wave.
that he
Excuse me. 'Tis of the wave and not
supporting
the
the
rock.
policies I
Tis
support.
but the
Right,
flapping of the sail,
Which
not
is
a rent
again, this guy is
made by
talking
the
about
gale.
how
In spite
the
of rock
Republicans are
and
talking
tempest
about how
and
down the
storm,
road
in
it would
spite
be
of
terrible
false lights on the
if
shore,
sail
sail on,
this
not
precedent
fear to breast
stood
the sea. Our
and
hearts
Democrats would be subject to
our
it
hopes
too, right? Like
are all with thee.
that's the same thing here.
Our
Like, what do you
hearts,
mean
our hopes,
you don't
our
care who the
prayers,
person is,
our tears,
but you want
our
that to
faith
happen?
triumphant,
That's exactly
triumphant over our fears, are all
And like,
Yeah,
I know
like
it's
care-
not representative of those individuals, but this guy is saying that he's representative.
Right.
Like, that not matter? Trump also said he was that
Right.
not matter. I think it's an issue
And that's
of law. It's,
that's like sort of a new cynicism, right? Like, otherwise, why did people care? Like back when there was the whole Clinton cheating thing, like people were all about like, oh, the character matters when you're the president. Like, where did that
which
go?
is true.
I don't...
It's true. Character matters. Like that should have mattered, right? Like, do you care that the president slept with an
Mr. President,
while he was president?
it's been a long day,
And we
well,
thank you,
and,
and
but
we
what's
thank all
funny
the
is that a lot of
senators for
it was the same kind of thing,
careful
politically
attention
motivated
to
thing where
the
a lot of
legal
Democrats
arguments
at the time said,
and your
like, that's his
courtesy to
personal
the
life. That's nothing to
managers
do
and
with
to
this.
the lawyers
I mean,
here.
this is much more egregious.
I think so
It's
too,
been the
but I
most
also
bipartisan
think like there's an
impeachment in
argument
American history, and we hope it will continue to
facing
be
the
so in the days
scrutiny.
ahead.
Like
Yeah.
being
Nothing
removed
could be
from
more
office, maybe not
bipartisan than the
necessarily,
desire
but
to
like
recess.
something.
Yeah,
So,
I agree.
The
Yeah,
only
that's
issue
what I'm saying is
before
I
the
think,
Senate
like,
today, of course, is whether
I don't know if everyone's
Donald
just
Trump
gotten
is
more
subject
cynical or
to
like if
the
it's
court of
gotten more
impeachment
partisan or I don't know
that
what
the
has
Senate
happened,
has
but
convened.
yeah,
We
for
see
people
no
to just
need
say
to
they
make
don't
any
care
further
about that.
argument.
Maybe the
is-
internet
body
just
has
has
the
like a
power
longer memory
to
than people
convict
do. So when you go and look
to
into it,
disqualify
oh yeah, this thing,
President Trump for
whereas
the
in the past,
breathtaking
like, say
constitutional
whatever,
crime of inciting a
takes way
violent
too much effort to
insurrection
fact check.
against our government. Tomorrow we will address the amazing array of issues suggested by the thoughtful presentations by our colleagues, including the First Amendment, due process, partisanship under our Constitution, the Bill of Attainder Clause, and many, many more. But in the meantime, we waive all further arguments. We waive our 33 minutes of rebuttal, and we give those 33 minutes gratefully back to the Senate of the United States.
All time yielded back, all time has been yielded back. Then the question is whether Donald John Trump is subject to the jurisdiction of a court of impeachment for acts committed while President of the United States, notwithstanding the expiration of his term in that office.
Nays, Mr. President.
Is there a sufficient second? There is a sufficient second, and the clerk shall call the roll.
Ms. Baldwin. Ms. Baldwin, aye. Mr. Barrasso. Mr. Barrasso, no. Mr. Bennett. Mr. Bennett, aye. Mrs. Blackburn. Mr. Blumenthal. Mr. Blumenthal, aye. Mr. Blunt. Mr. Blunt, no. Mr. Booker. Mr. Booker, aye. Mr. Bozeman. Mr. Bozeman, no. Mr. Braun. Mr. Braun, no. Mr. Brown. Mr. Brown, aye. Mr. Burr. Mr. Burr, no. Ms. Cantwell. Ms. Cantwell, aye. Mrs. Capito. Mrs. Capito, no. Mr. Cardin. Mr. Cardin, aye. Mr. Carper. Mr. Carper, aye. Mr. Casey. Mr. Casey, aye. Mr. Cassidy. Mr. Cassidy, aye. Ms. Collins. Ms. Collins, aye. Mr. Coons. Mr. Coons, aye. Mr. Cornyn. Mr. Cornyn, no. Ms. Cortez Masto. Ms. Cortez Masto, aye. Mr. Cotton. Mr. Cotton, no. Mr. Kramer. Mr. Kramer, no. Mr. Crapo. Mr. Crapo, no. Mr. Cruz. Mr. Cruz, no. Mr. Daines. Mr. Daines, no. Ms. Duckworth. Ms. Duckworth, aye. Mr. Durbin. Mr. Durbin, aye. Ms. Ernst. Ms. Ernst, no. Mrs. Feinstein. Mrs. Feinstein, aye. Mrs. Fisher. Mrs. Fisher, no. Mrs. Gillibrand. Mrs. Gillibrand, aye. Mr. Graham. Mr. Graham, no. Mr. Grassley. Mr. Grassley, no. Mr. Haggerty. Mr. Haggerty, no. Ms. Hassan. Ms. Hassan, aye. Mr. Hawley. Mr. Hawley, no. Mr. Heinrich. Mr. Heinrich, aye. Mr. Hickenlooper. Mr. Hickenlooper, aye. Ms. Hirono. Ms. Hirono, aye. Mr. Hoven. Mr. Hoven, no. Mrs. Hyde-Smith. No. Mrs. Hyde-Smith, no. Mr. Inhofe. Mr. Inhofe, no. Mr. Johnson. Mr. Johnson, no. Mr. Kane. Mr. Kane, aye. Mr. Kelly. Mr. Kelly, aye. Mr. Kennedy. No. Mr. Kennedy, no. Mr. King. Aye. Mr. King, aye. Ms. Klobuchar. Ms. Klobuchar, aye. Mr. Langford? Mr. Langford, no. Mr. Leahy? Mr. Leahy, aye. Mr. Lee? Mr. Lee, no. Mr. Lujan? Mr. Lujan, aye. Ms. Lummis? Ms. Lummis, no. Mr. Manchin? Mr. Manchin, aye. Mr. Markey? Mr. Markey, aye. Mr. Marshall? Mr. Marshall, no. Mr. McConnell? Mr. McConnell, no. Mr. Menendez? Mr. Menendez, aye. Mr. Merkley? Mr. Merkley, aye. Mr. Moran? Ms. Murkowski? Ms. Murkowski, aye. Mr. Murphy? Mr. Murphy, aye. Mrs. Murray? Mrs. Murray, aye. Mr. Ossoff? Mr. Ossoff, aye. Mr. Padilla? Mr. Padilla, aye. Mr. Paul? Mr. Paul, no. Mr. Peters? Mr. Peters, aye. Mr. Portman? Mr. Portman, no. Mr. Reed? Mr. Reed, aye. Mr. Risch? Mr. Risch, no. Mr. Romney? Mr. Romney, aye. Ms. Rosen? Ms. Rosen, aye. Mr. Rounds? Mr. Rounds, no. Mr. Rubio? Mr. Rubio, no. Mr. Sanders? Mr. Sanders, aye. Mr. Sass? Mr. Sass, aye. Mr. Schatz? Mr. Schatz, aye. Mr. Schumer? Mr. Schumer, aye. Mr. Scott of Florida? Mr. Scott of Florida, no. Mr. Scott of South Carolina? Mr. Scott of South Carolina, no. Mrs. Shaheen? Mrs. Shaheen, aye. Mr. Shelby? Mr. Shelby, no. Ms. Sinema? Ms. Sinema, aye. Ms. Smith? Ms. Smith, aye. Ms. Stabenow? Ms. Stabenow, aye. Mr. Sullivan? Mr. Sullivan, no. Mr. Tester? Mr. Tester, aye. Mr. Thune? Mr. Thune, no. Mr. Tillis? Mr. Tillis, no. Mr. Toomey? Mr. Toomey, aye. Mr. Tuberville? Mr. Tuberville, no. Mr. Van Hollen? Mr. Van Hollen, aye. Mr. Warner? Mr. Warner, aye. Mr. Warnock? Mr. Warnock, aye. Ms. Warren? Ms. Warren, aye. Mr. Whitehouse? Mr. Whitehouse, aye. Mr. Wicker? Mr. Wicker, no. Mr. Wyden? Mr. Wyden, aye. Mr. Young? Mr. Young, no. Mr. Moran? Mr. Moran, no. Mrs. Blackburn? Mrs. Blackburn, no. The yeas are 56 and the nays are 44, and then Elizabeth will have something for the read.
On this vote, the yeas are 56, the nays are 44, and pursuant to S. Res. 47, the Senate having voted in the affirmative on the foregoing question, the Senate shall proceed with the trial as provided under the provisions of that resolution.
Mr. President.
Majority Leader.
I ask unanimous consent that the trial adjourn until 12 noon tomorrow, Wednesday, February 10th, and that this order also constitute the adjournment of the Senate.
Without objection, we shall stand in adjournment until noon tomorrow.
They adjourned.
They give the tally?
I didn't hear a tally. I just heard the adjournment. Were they actually voting today?
Yeah, they just voted on whether the Senate had...
Oh, I thought they were going to do that for 2 days. Okay.
Which is different than actually voting to impeach. It's just saying that the Senate has the right to hear. Which is crazy to me that it's so down the middle on this. They do have the right to hear the trial. They're voting themselves on whether they have the right to hear the trial. I think that speaks volumes. But
at least this part. I guess we'll be back tomorrow. Adios.